Irreparable harm is the most significant of all the elements you're going to be required to establish to obtain a preliminary injunction. And that is because you need to show to the court in an emergency manner, if the court does not grant the relief you're seeking, then there's going to be imminent damage that is more than simply a financial loss. And what do I mean by that? If you're seeking to sue somebody because they failed to pay a lender back you as the lender on a promissory note, then your ultimate award is monetary damages only. Preliminary injunctions cannot and will not attach when the relief sought is simply a monetary damage. But if there's something else involved, something tangible, assets, property, that's a different story. For example, if a defendant is trying to sell shares that belong to you in a company, you might be able to get an injunction. If a defendant and a bad faith actor is depleting the company bank account or diverting company assets to a third-party company, you might be able to get an injunction. Confidential information, trade secrets of the company. If somebody's threatening to expose that information, or if they're doing that and you need to enjoin them from doing it further, that would be a justification to obtain a preliminary injunction. And because of this emergency nature of these types of applications to the court, it's essential that you come forward with documentary proof, you come forward with clarity concerning the relief you're seeking, the justification and causation for why it's needed. Otherwise, a court is unlikely to grant this type of emergency relief. The third element you need to establish is to show that a balancing of equities is in the favor of the plaintiff. In those situations, the court is going to consider the potential damage to the plaintiff if the relief is not granted, as compared to the potential damage to the defendant if the relief is granted. In those types of situations, it's very important to show why the aggrieved party, you as the plaintiff, will suffer significant damages that are well above and beyond the potential damage to the defendant if this relief is granted. Now, bond is a form of collateral whereby the court requires the plaintiff to post it so that in the event that at the end of the litigation, after it goes to trial, it's determined that the injunction actually should not have been granted in the first place, the defendant has a mechanism and means of recovering monetary damages. Oftentimes, court will require a plaintiff to post bond as part of their application to obtain a preliminary injunction. However, there are circumstances, which again are determined on a case-by-case basis, where a court will actually allow the plaintiff to obtain an injunction and will not require that plaintiff to post bond. Therefore, it is always suggested that you make the argument as to why bond should not have to be posted as part of the plaintiff's application.